Good afternoon. I'm Steve Bloddick. I'm a professor of law and the Associate Dean for Scholarship here at the American University Washington College of Law. It's my pleasure to welcome you to today's event, Corporate Liability for Human Rights Violations Outside the United States, a day after assessment of the Kiobel versus Royal Dutch Petroleum re-argument in the Supreme Court. This event is being broadcast live on C-SPAN, so if you're following at home, please know that you can send questions for our speakers to humlaw@wcl.american.edu for the question and answer time. Before we get started, just a couple of quick announcements. First, we'd like to thank the Jennifer Dobson and her staff here at WCL, the Special Events and Continuing Legal Education Office, the facilities and public relations teams, the AV and technology folks, and everyone else who has helped put this event together today, including the staff at EarthRights International, which helped to line up the speakers. We'd like to thank our speakers for coming. This discussion is being co-sponsored by the Washington College of Law Center for Human Rights and Humanitarian Law, the Program on International and Comparative Environmental Law, and the International Legal Studies Program, along with EarthRights International. And before I introduce the speakers, one other quick announcement. For those interested in these issues, WCL is also hosting a conference on Monday, October 15th, about the future of the Inter-American Human Rights System. You can check out the website of WCL Center for Human Rights and Humanitarian Law for more information about that conference. So as everybody knows, yesterday, in its first argument of the term, the Supreme Court heard re-argument in Kiobel versus Royal Dutch Petroleum, a case raising the question of corporate and extraterritorial liability under the Allen Tort Statute or the Allen Tort Claims Act. And so we brought together this panel to revisit yesterday's argument, to talk about what we might take away from the argument and the future of human rights litigation under the Allen Tort Statute going forward. I'm going to briefly introduce our panelists. You actually have far more complete biographies in your materials, but in the order in which they're speaking. First to my left is Katie Redford, who's co-founder and the U.S. Office Director of EarthRights International. After Katie will be Paul Hoffman, who, among other things, was lead counsel for the plaintiffs in Kiobel and argued yesterday before the Supreme Court. To Paul's left is John Bellinger, who's a partner in Arnold and Porter and the former legal advisor at the State Department, and who co-authored an amicus brief in the Kiobel case. And finally, Andrew Grossman, who's a litigator at BakerHostetler and legal fellow at the Heritage Foundation. Each of the panels is going to give about 10 minutes of opening remarks, and then we'll open it to Q&A. So with that, Katie, why don't you lead off?
Sure, thank you. Great to see everyone here today. It's really wonderful to see so many students interested in this topic and in this case. It's really, really important. And before we talk about sort of what happened yesterday and what this may mean for the future of the Allen Tort Statute, I wanted to give you a little bit of the history and how we got to this moment in history right now with this law. And very coincidentally and nicely, it started for me when I was in law school as a law student back in the 90s at University of Virginia. Went to law school because I was passionate about human rights, passionate about justice, and thought that being a lawyer, like many of us think, being a lawyer means that you develop the skills and the expertise to work for justice, to work on behalf of people and communities who need the law to raise their rights and vindicate their rights. And I studied the Allen Tort Statute, which on its face, all it says, basically, is that district courts shall have jurisdiction for claims by an alien committed for tort only, committed in violation of the law of nations or a treaty of the United States. And this law was used in the 1970s, even though it was written and passed in 200 years ago by the first Congress of the United States. It remained kind of dormant and was awoken in the 1970s as a human rights law when lawyers from the Center for Constitutional Rights brought the Philartica case, which got a lot of play yesterday in the court, brought on behalf of a Paraguayan family whose brother and son was tortured to death in Paraguay by a Paraguayan defendant. And again, alien, the Paraguayan plaintiff, torture, extrajudicial killing, and that was deemed to be in violation of the law of nations. Human rights law in the Philartica case was deemed to be in violation of the law of nations, and this sort of field of human rights litigation under the Allen Tort Statute began. And for the purposes of the argument, let's just remember the seminal case. Three things happened outside of the United States: the plaintiff, the defendant, and the actions all happened in Paraguay. So I was inspired by this law. I thought, okay, now I know why I went to law school. I'm going to do these kinds of cases. And I spent a lot of time during my summers on the Thai-Burma border in refugee camps. And there I met human rights survivors, victims of the same kinds of abuses that were at issue in the Filartiga case. But this time, the people that I talked to, the people that I met, were people who were running from human rights abuses in Burma that were connected to a U.S. oil company, that were connected to a corporation, Unical, California corporation, that had hired the Burmese military, had gone into contract with the Burmese military to provide security for their gas pipeline. And in fulfilling the contract and in providing security for the pipeline, the Burmese military, on Unical's behalf, forced thousands of people to build military barracks for their pipeline security forces, forced people to work on infrastructure for the pipeline, like bridges, helicopter landing pads, roads. Security forces guarding the pipeline did what Burmese security forces were notorious for, and still are: rape, torture, and killing of anyone who got in the way. So I went back to my book and I looked at the Alien Tort Statute, and I'm thinking, is there any reason why we can't bring a Filartiga type case against Unical? Alien, people from Burma, tort, torture, killing, rape, slave labor, violation of the law of nations. And I thought, nope, I'm a pretty smart law student. I don't see any reason why we can't. And so that is why we started EarthRights International, to use the Alien Tort Statute, to use the law as a tool for justice for people like those people who became our clients in what became the first corporate case under the Alien Tort Statute, known as Doe v. Unical. And I will say, since we have a lot of law students, most of my professors, when I told them about this idea, thought it was crazy. And they were like, you can't do that. You can't sue a corporation for human rights abuses. And I said, well, you're just saying that because nobody ever has. And so I found someone right here who was willing to go along with it, and someone who had a lot of experience doing Alien Tort Statute cases, and together with a team of lawyers, we did file the case, and the California court granted jurisdiction over Unical for the human rights abuses associated with its pipeline in Burma. Our clients had family members killed. One of our clients, Jane Doe 1, was tortured while she was holding her baby, nursing her baby by a cooking fire, and she and her baby were kicked into the fire by pipeline security forces, and her baby later died. We had clients who did slave labor building helicopter landing pads for Unical's pipeline and other infrastructure for the pipeline. Egregious human rights abuses, terrible suffering, and our clients, because of this law, just could get their foot in the door and have a chance to tell their story to a court and seek justice for the human rights abuses that Unical was complicit in. Shell, yesterday, and in their briefs leading up to this case yesterday, is basically arguing to turn back the clock to a pre-Unical world, to a time where corporations, as long as they are operating overseas, cannot be brought to account in U.S. courts under the Alien Tort Statute for human rights abuses in which they're complicit. Since the Doe v. Unical case sort of established this opportunity, this precedent, allowing corporations to be sued, we've been able to bring cases, and others have brought cases, challenging corporations' complicity in the Holocaust, crimes against humanity in Sudan, torture and killings in Indonesia, war crimes in Papua New Guinea. And right now, we at EarthRights have a lawsuit against Chiquita for their complicity in hiring paramilitary death squads in Colombia, which involves thousands of victims of these egregious human rights abuses. So yesterday, the Supreme Court heard arguments that will decide the legacy of Doe v. Unical and the corporate cases that came behind it, and answer the question whether corporations present in the United States can be held accountable here for the worst human rights abuses, no matter where they occur. And we'll find out whether that will remain intact. In Kiobel v. Royal Dutch Petroleum, the court will consider whether any lawsuits, not only corporate lawsuits, but actually the defendants have asked them to reconsider the entire history of the ATS, whether any lawsuits, Philartiga and beyond, under the ATS can be brought against corporations or any other abuses by any individuals that happen in other countries. Shell is accused of conspiring with and abetting the Nigerian military in committing crimes against humanity and illegal executions of Ogoni people who opposed Shell's oil operations in their territory. Shell is arguing to the Supreme Court, Shell did argue to the Supreme Court that even if they did these things, even if they asked the Nigerian military to brutally suppress the Ogoni movement and execute its leaders, they cannot be held responsible, both because the abuses happened in Nigeria and because they're a corporation. You'll hear from Paul and others how they think the arguments went yesterday. And I'll just say, from where I sat, I thought it went pretty well. But what would happen if the Supreme Court rules that Shell cannot be sued? It may be that no more ATS cases can be brought against corporations. The ATS is a critical legal tool in corporate accountability for human rights abuses and in justice and accountability for all survivors of human rights abuses, whether they were committed, abetted, aided by corporations or others. We won't stop seeking justice for the victims, regardless of what happens. But we will also need to make sure that there are avenues, and new lawyers like yourselves to bring these kinds of cases, to find new ways to hold corporations accountable for the abuses that they commit wherever they are committed, because it's not true, and it can't be true, that what Shell's arguing, what happened in Nigeria, stays in Nigeria. They're present in this country. Our courts should keep their doors open to allow people just to have a chance to tell their stories and seek justice. And that's what's at stake in this case, and that's what we're going to find out from the Supreme Court. Thank you.
Thanks, Katie.
Thanks. Thanks to Katie for giving you such a great introduction to the reason why we bring these cases. I'm going to turn to what happened yesterday, because that's what I've been asked to talk about. And the points that, obviously, I've been immersed in this now for quite some time. And now that I don't have to argue in front of the Supreme Court again, I'm much more relaxed this year. The points, I sort of was trying to think of what the most important points were from my perspective. One point is that the defendants in the case, Shell and its amici, including my colleague John Bellinger to my left, took very extreme positions against our position in the case. In fact, in the Sosa case, which was argued 8 years ago, the first case that the Supreme Court decided on the Allen Tort Statute, most of the issues that the defendants and their amici were raising, to my mind, really were resolved in Sosa. Certainly their essence was resolved. Whether the court actually said in so many words they were resolved is a matter for some debate. But everybody knew in the Sosa case that what was at stake was the whole Philartiga precedent. All of the same arguments were raised 8 years ago in that case. And the court decided, after hearing all those arguments, that the Alien Tort Statute could be used to challenge modern international and human rights violations. Now, to be sure, the Supreme Court left open many questions about exactly which human rights violations could be vindicated and other issues. But it endorsed the Philartiga case, and by endorsing that line of cases, I think at least implicitly, and I think more than that, endorsed the idea that U.S. courts could hear human rights claims that arose on foreign soil. Because virtually all of the cases that we had litigated prior to SOSA, including cases against corporations, had arisen on foreign soil. There were not cases that arose within U.S. territory. There were not cases that arose on the high seas. We were not chasing pirates. But we were chasing the modern-day pirates, the torturers, those committing genocide, those committing slave labor. So, and one of the things that struck me yesterday in the court and in a lot of the questioning was that the Supreme Court, whatever one thinks ideologically and tries to guess about where the Supreme Court's going to come out, precedent matters. You had lots of questions yesterday that were based on SOSA and based on the words in SOSA and based on SOSA's endorsement of the Filartiga case. That justices, particularly in questioning Shell's counsel, were trying to force her to come to grips with the fact that the court really had said these things 8 years ago, and that they mattered, that they weren't things to be trifled with. And so I think that the importance of precedent is something to bear in mind. And I think when the court decides things, even justices that may not have agreed with the original decision become part of a process where you don't just discard precedent because you might not have voted that way the first time around. And I think that, like the Sosa case, I think that the arguments that were made against our case here were very extreme arguments, that the Alien Tort Statute never was extraterritorial. And I think the history on that just blows that argument out of the water, because we were able to find diplomatic correspondence that had to do with an incident shortly after the Alien Tort Statute, which clearly occurred on foreign soil and where the Attorney General of the United States, Attorney General Redford, in 1795 said that the Alien Tort Statute was available to vindicate those particular claims, which had to do with breach of neutrality, where American citizens were aiding the French in an attack on the Sierra Leone colony that was British territory. So the idea that the statute could never be used extraterritorially was a very extreme position. And it did not seem that the court was very interested in that. And I think the idea that corporations can never be sued, that you can single out that category of defendants so that they can never be sued, is also an extreme position that I don't think is very well supported. And I think the other thing that Shell and at least some amici did was take a fairly radical position, it seems to me, about the principles of international law. One of the principles of international law is that states have the discretion to act unless there's some norm that prevents them from acting. And in this particular context, the question is, do states, meaning governments, countries, do they have the ability to enforce international human rights law in various ways? Can they do that by implementing principles of universal jurisdiction, where if torturers appear on your shores, whether the torture occurred within your territory, whether the torturer is one of your nationals, can those governments take action in support of the entire international community so that we can eliminate the scourge of torture and genocide and slavery from the world today? There's controversy about all that, but it seems that the respondents, Shell, took the position that international law is much more restrictive than that. Until there's an agreement that it can be done, generally states can't act. And I think that's the opposite of the way the international law system works. Now, again, there's dispute about this, and I'm sure Mr. Bellinger will correct my international law on this. But I think that one of the problems that the court will have is that if the other side's position on international law is accepted, then the United States is an international law violator in a lot of respects, including passing the Torture Victim Protection Act, where the Congress actually passed a law to do precisely what the Alien Tort Statute does. And under the respondents' analysis, that's a violation of international law. And I think that would come as a great surprise to the Congress. It would come as a great surprise to President Bush, who signed it, and probably a great surprise to the entire international community, because no one protested that, as far as I'm concerned, and no one, as far as I know, has protested an Alien Torture Victim Protection Act case. So where does that leave us? Now, the court clearly, from the argument in February, has expressed some concern about the circumstances in which foreign plaintiffs can sue foreign corporations within the United States for things that happen outside the United States. Now, one of our arguments to the court is that our clients they're aliens in the sense that they're Nigerian citizens when they filed the suit. But the reason they're in the United States, all of them were U.S. residents when they filed. In fact, all of them have gotten asylum in the United States, and they got asylum in the United States because of the human rights violations that they allege Shell was complicit in Agoni. And Shell is here, making lots of money here. And one of the things that our clients found was that wherever they lived, and they all lived somewhere in the Midwest, all they could see, they saw Shell stations all around them, just like back home. And they thought, well, Shell is really here. Why can't we sue them here? And that's the issue at the heart of the case, really. Why can't people who have strong ties to the United States now, and they have those ties because of these human rights violations, why can't they sue Shell here for the torts that they committed against them in Nigeria? But the court is concerned about that, and they're concerned not just about our case, obviously, but they're concerned about setting rules about these cases. And I think the court's struggling to find some compromise. At least that seemed to be what was going on in the questioning yesterday about what the principles should be, so that not every case could be brought, particularly if there are other places where the case can be litigated. And so it's possible that the court will consider an exhaustion of local remedies requirement of some kind. There was a lot of discussion about that. But I think that the court, at least based on the argument, and it's always very dangerous to base anything on the argument. I know that from many years of experience, that you can never predict. It seemed unlikely that the court was accepting categorical positions, and that they were inclined to overrule their precedent of only 8 years ago. I think it's more likely that the court will struggle to find some way of moving forward, so that John Bellinger and I can get back to litigating all the issues that we were litigating before this case went up, which the definition of aiding and abetting and all these other things, so that we can have fun doing that for a while. But I think that's the most likely result of all this. But we'll see what the court does when we get a decision.
Paul, are you at least confident that there won't be a second re-argument order?
Well, when I went home last time in February, I went to sleep for about 3 days. And then when I walked into my office, and as I walked into my office, I had a call from the clerk of the Supreme Court saying, I'd like to read you this order. Right? Now, it turns out that my wife and I are going back to the same place in San Diego this weekend. And so when I walk in on Monday, I'm not answering the phone. That's for sure.
Great. Thanks, John.
Great. Thanks. And thank you all for having me here. Didn't Washington College before, but it's been a couple of years. I'm speaking today really not as an advocate in the current case, although I have filed a couple of briefs that I will talk about, but really as someone who was the State Department legal advisor for 4 years and who had to deal as a government official with a lot of these cases. And so I hope what I leave you with at the end here and with some of the questions is how a U.S. government official grapples with some of these questions, because I completely understand half of me where Paul and Katie are coming from, and when there are human rights violations in the world, and all of us know that there are, if they are committed by individuals, if they are committed by corporations, people need to be held accountable for that. The question is that one permissible under international law as it is now? And second, is that the statute that Congress has written, and should judges interpret it that way? So just my experience, let me just talk to you a little bit about my experience in these cases. When I became legal advisor, I had a whole line of countries coming in to complain about lawsuits that had been brought in the United States against either their officials or against corporations of their nationality, complaining that it was a violation of international law for U.S. courts to be judging acts that occurred in the territory of other countries where there was no nexus to the United States. So the view, certainly, of almost all other countries in the world, including most of our closest allies, the British, the Australians, the Canadians, the Swiss, the Germans, all believe, and these are countries that are strong believers in human rights, that it's not up to the courts in the United States to be judging actions that didn't occur on U.S. soil or didn't involve their nationals. So during the period of time that I was legal advisor, we had a whole lot of different demarches, letters, diplomatic protests saying that the Alien Tort Statute, far from upholding international law, is in fact a violation of international law. Now, maybe you can argue that these countries are just trying to protect their own officials or protect their own corporations. But what I can tell you is that other countries in the world believe that the Alien Tort Statute, even if the policy that Paul and others are urging on us, in fact, violates basic principles of international law. During the Bush administration, when the U.S. government was asked for its views on these cases, we, in fact, did file a number of briefs in different courts and lower courts, including in the Supreme Court, arguing that the Alien Tort Statute of 1789 was never intended to apply to torts that occurred in other countries. The framers would have thought it absurd for the fledgling courts of the New Republic in 1789 to be hearing cases brought by victims of the French Revolution saying that they had been improperly guillotined and that the courts in France would not hear their cases, so they were brought to the United States for a federal judge to hear whether France had violated the human rights of victims inside France. Now, Paul has a slightly different view on this, but I think the slightly different view on it is even if you believe that that was not what the framers intended in 1789, because I think Paul would be hard-pressed to say that the framers said that our courts in 1790 should hear the case of a human rights victim in France. That was not what this statute was intended to do. The question then is, over the last 200 years, should the courts now interpret the statute that way, even though it was not intended to be interpreted that way over time? It was rediscovered in the 1980s and used for this purpose. And the key question then is, even though Congress may not have intended it to be used that way, should courts appropriately interpret it that way, essentially to move the law in a new direction? Or is that more appropriately left to Congress to make that decision, which is in fact exactly what they did in the Torture Victims Protection Act, which allows lawsuits against a category of individuals for torture and other human rights violations. So a key question for you to think about is, even if corporations or individuals should be held liable in U.S. courts for human rights violations, which is a perfectly appropriate argument. Congress did decide that in the Torture Victims Protection Act. Should the courts today decide on their own that these 25 cryptic words from 1789 are intended to do those things? Now, let me be clear, and I don't want to go too far on this, but the views that we were articulating in the Bush administration were really not political views of the administration. These were the best arguments of the career lawyers at the Justice Department and of the State Department on how the 1789 Alien Tort Statute ought to be interpreted. That was their best view on how that ought to be interpreted. Now, in this case, Paul Clement, the former Solicitor General, and I, who had filed briefs on behalf of the Bush administration, teamed up again essentially to write the same briefs on behalf of a group of companies who had been sued in these cases. And we cataloged in our brief in the first round in February, when everybody else was arguing the corporate liability point, we wanted to reprise this argument about, was the Alien Tort Statute ever intended by Congress, and should it be interpreted now to apply extraterritorially? And we pointed out the views of other countries who believe that it is a violation of international law for courts to judge actions that have no nexus to the United States. I must say, I was surprised myself when the court ordered the case to be rebriefed and re-argued on this very issue. I don't spend enough time before the Supreme Court to know how many times that happens, but it's very rare for the court. If they like an issue, they may just sort of decide it in the case. It's rare that they will actually order the whole case rebriefed and re-argued. So on the extraterritoriality issue, it's now been completely focused. Paul did a very good job yesterday, really reiterating the points that you just heard of why this is what the law ought to be. And I can make those arguments as well, that that's what the law ought to be. The question is that the law that Congress wrote? Is that in fact consistent with international law as it is now? Or are these decisions more appropriately made by Congress as they wwere made in the Torture Victims Protection Act? Let me say a couple of words about the argument yesterday and then end with a question. Since I don't know how many of you all looked through the transcript, I'll go through. It was fairly predictable in a lot of ways. The conservative justices, Scalia, Roberts, and Alito, reiterated the points that they had made in February and really had pushed Paul on. Why are these cases in our courts? What possible connection to our courts do these cases that involve a foreign corporation in a foreign country and a foreign government have in the United States? The more liberal justices, I would say, were really not so much pushing back on that point, but trying to preserve Philartica. The idea that at least with respect to lawsuits against foreign government officials who have really done terrible things, that the Alien Tort Statute ought to at least continue to be allowed to preserve those kinds of cases. And they really pushed, it seemed to be clear that there are at least 4 justices who would like to preserve Philartica. Those who I would say are a bit more in the middle, or at least the newer justices to the court, Elena Kagan, who was a law school classmate of mine, and Justice Sotomayor, seem to be trying to strike a middle ground. In fact, they were questioning really whether it was appropriate for courts to be hearing a case involving a foreign corporation on foreign territory, or at least whether other avenues hadn't been exhausted. Justice Sotomayor in particular said, have you exhausted all the remedies that could have been brought either in Nigeria, or at least since this is a Dutch or British company, to have brought it in Britain or the Netherlands first? Justice Kennedy was really concerned about reciprocity, and this is a key point that I want you to remember, because this is perhaps one of the greatest concerns of the U.S. government, is would we be comfortable if other countries did this to us? Would we be comfortable when other countries say that this is a violation of international law for the United States to be judging actions that here in their country? Would we be comfortable if Germany or the UK or the Netherlands were to set up essentially an international civil jurisdiction statute and apply that to U.S. government officials? I can tell you, as the former State Department legal advisor, we have protested consistently over decades when other countries have tried to apply international civil jurisdiction. Now, let me end with this point, because many of you all are lawyers who would like to, I hope, go into international law. So now think about it for a minute. Almost all lawyers have a client for a point of view. Assume for a moment that you are now either the legal advisor for the State Department, or I hope some of you will be a assistant legal advisor or someone who joins the office, and you are sitting down with Hillary Clinton right now, and you are saying to her basically these arguments that you've just heard as to why it is critically important for U.S. courts to be open for the violations of international human rights that can't be brought anywhere else to be heard here in the United States. And she will say to you, that makes sense to me. And then you would say to her, though, but Madam Secretary, I need to tell you as your lawyer, if we make this argument here, you need to be comfortable that you will be sued and Leon Panetta will be sued outside the United States, and we will not be able to complain. So, Madam Secretary, when you and Leon Panetta approve the drone strikes in Yemen or in Pakistan, are you comfortable that you personally and the Secretary of Defense will be sued in Germany, in the Netherlands, or elsewhere for their acts in third countries and have a judge in a foreign country hear that case even though it has no nexus? So this is the question of reciprocity. I can tell you from all the lawyers inside the State Department, that's a very difficult issue because many of them have come from out of the same human rights clinics, and at least half of their brain or more of it really, and me as well, wants there to be accountability for these cases. But at the same time, one, did Congress write the law that way? Should judges rewrite a law that Congress was not clear should apply to these kinds of cases? And would we really be comfortable on our own deciding reciprocally that these cases can be heard in other countries, exposing the United States to the same kinds of actions around the world? So I'll end with that and take more questions.
Andrew.
I'm going to start by offering a few observations on yesterday's oral argument and then discuss what I think is a fundamental question lurking behind all of this. I find it kind of remarkable that nobody has identified what seems to me to be the big 40-point font headline from yesterday's oral argument, which is 8 justices asked questions, and every single one of them expressed, I think, more than some concerns, I think very serious concerns about the way that the Allen Tort Statute is being applied in human rights litigation. Each one of those 8 justices asked questions, and I admit it's very difficult and sometimes fraught with peril to predict a judge's mind and his thoughts based on his questions, but all 8 of them asked questions directed at the specific limitations on the availability and application of the Allen Tort Statute in precisely this type of litigation. You had Scalia, Alito, Kennedy, and Roberts discussing, in a straightforward sense, the extraterritorial issue. Justice Kennedy and the Chief Justice focused on the reciprocity issue that John discussed. Alito, Kennedy, and Breyer were asking very pointed questions regarding U.S. foreign policy interests, something that I'll note that Justice Breyer wrote about in his concurrence in Sosa. And then you had Justices Ginsburg, Sotomayor, Kagan, and Scalia bringing up specifically the idea whether the ATS merely provides a jurisdiction of necessity, in other words, where jurisdiction is unavailable in forums that have a greater connection to the conducted issue or a greater connection to the defendants. Coming with that idea of jurisdiction of necessity, you would also have, presumably, some type of exhaustion requirements. The plaintiff would either have to bring suit in those areas or attempt to, or determine and present some evidence that doing so would be futile. The latter two, both the jurisdiction of necessity issue as well as U.S. foreign policy issues, were issues that specifically the court left open in Sosa. There's a footnote in Sosa that discusses these and says, well, they're very interesting issues, and maybe they'll come up in some future case. And gosh, a lot did come up in oral argument yesterday, and that was just part of it. Well, what can we conclude just from this little rundown, just looking at the numbers? I think we can conclude that the Kiobel litigation is probably in trouble. I didn't see, and maybe I'm wrong and maybe I'm blind to these things, but I think it was difficult for me to see a justice who appeared particularly sympathetic to the theory of liability that's being put forward in this case. But let me actually be even more precise than that. To the idea that this particular case, in these particular circumstances, is being tried in U.S. federal courts. Now, like that or lump that, That's just an observation of the justices' expressions and the questions they asked and the way that they approached it. Even Justice Kagan, in an offhanded manner, when she was discussing, when she was talking with Kathleen Sullivan, who is the respondent's counsel, Shell's counsel, said, well, you may well get off in this case, and then proceeded to ask questions about future cases. So we can certainly say that the court has both a narrow view and a broader view of what to do in this case. And in that sense, it's not unlike Sosa. Paul Hoffman spent a lot of his discussion stressing the stare decisis virtue of following Sosa and embracing Sosa. But one must remember, of course, that the plaintiffs in Sosa lost. And in that instance, the court did take what I would think is fair to call an incremental step toward narrowing ATS liability, or at least ATS jurisdiction, in a way that the court seemed to think, and I think this underlies certainly the majority opinion, would take a lot of these more far-flung cases out of the federal courts. Well, I think looking back on it, what the court is seeing now is that probably hasn't worked. Again, you can debate whether that's the proper aim for the court to have, but I think it's fair to say that Sosa did not provide very much certainty as to some of the most basic threshold issues regarding the Alien Tort Statute and how it might operate in particular cases. The results has been many, many cases with uncertain outcomes, lots of potential liability in cases where maybe there ought to be or maybe there ought not to be, endless rounds of briefing. And it's something that I think has actually been detrimental not only to defendants, who have to obviously defend against some of these claims, some of which are meritorious and some of which may not be, but has also been detrimental to plaintiffs. I think there has been, to some extent, a misdirection of resources towards litigation that might better be directed towards political action or other ends that have, I think, more durable outcomes. So I think the question that the court has left, and really what the court was struggling with is, what is the purpose of all of this? Not the broader question, I think the question that animates a lot of discussion in these issues, which is, how do we deal with human rights writ large? But the much narrower question, just what is the ATS for? Sosa can be read very, very narrowly, can be read very, very broadly. And I think on the court you saw a little bit of pushback in both directions. It was notable that the chief at one point said, well, we decided this issue in Sosa. It was hard to tell whether he was smirking or whether he was actually putting that forward. But the truth of the matter is that if a majority of the court wants to do something that runs against the essence of Sosa, I don't know what the essence of Sosa is, but something against the essence of Sosa or the emanations of Sosa, they will have the votes to do that. But I think in a legitimizing legal sense, they will have the legal wherewithal to do that as well, because the Sosa opinion, for all of its length and for its great discussion, didn't really resolve all that much. So I'm going to tell you a little bit what I think, as shown by some of the questioning, what I think would be an interesting way for the court at least to resolve the Alien Tort Statute, in my mind, probably the correct way. At the time that Sosa came forward, there were a lot of ideas about the meaning of the Alien Tort Statute. There was a lot of sort of hand-waving and lawyers' history as to what it was the framing generation of the first Congress were thinking about. But there hadn't actually been a lot of the actual spelunking through the historical archives, looking at the statutes, looking at the foreign policy decisions at the time, looking at sort of that broader context, how the Confederation Congress, prior to the U.S. Congress, had dealt with these types of issues. And the idea that that the ATS reaches sort of human rights violations and international law norms writ large comes from effectively a single sentence in Blackstone's commentaries on British law. That sentence identifies three violations, three obligations, rather, of international law that Blackstone believed were properly carried over in a hybrid fashion into a country's domestic law. In other words, while sovereigns are usually the objects of international law obligations, not in every case, but in the main, these three had such importance and had such fraught foreign policy consequences and were susceptible to judging by the courts that a sovereign was perhaps in violation of its international law obligations, or at least risking violation of those obligations by not criminalizing or at least providing some mechanism of dealing with those three things. They were safe conduct, piracy, and infringements of the rights of ambassadors. Now, Sosa took that sentence and the little bit of lawyer's history that had been done up till then and said, well, we're going to generalize from those specific norms, those international law norms, into this idea that the ATS is directed at all durable and current international law norms. And that might include the types of human rights violations that are at issue in cases such as Kiobel. It might include any number of things that are subjects of treaties. But what we've come up with, when we looked through all the historical materials and we've tried to figure out what it was that Congress was up to, is that it actually, and I think there was a very strong original meaning argument, was not that broad. Piracy was covered by two separate provisions of the same act that included the Alien Tort Statute. It was not a standalone statute. It was about one sentence in a far larger judiciary act. Infringements against ambassadors were also covered in separate provisions of that statute. That leaves safe conducts. Safe conducts are rights that, although they're owed to a foreign sovereign, actually adhere to subjects and citizens of that sovereign when they travel in a foreign country. When a person is admitted into a foreign country, that country has an obligation to see that they are able to conduct safely through that country. That is a treaty right, and it is a right under international law. The language of the Alien Tort Statute actually mirrors this understanding pretty closely. In legal documents of the time in legislation, alien generally referred to a foreign person outside of his home state. In other words, a foreign person who might be here within the United States. The reference to international law and treaties fits the two sources of safe conduct obligations. And there was this concern also in Blackstone that these other types of norms, other sorts of obligations, just weren't things that were really subject to judging, to justiciability. So when you look at the history, and I'm sure that Paul and Katie will argue on the history, and that's a really rich topic, one that I really enjoy discussing. But I think when you take a fair-minded view of this and try and figure out what it was that first Congress was doing, it was actually relatively modest and really, in the end, had very little to do with human rights. It doesn't mean that human rights are not worth pursuing. It doesn't mean they're not worth pursuing and enforcing in the courts. It just may simply mean that the Alien Tort Statute is perhaps not the right mechanism to do that. Thank you.
So before we get to audience questions, I want to give the panelists a chance to sort of respond to each other a little bit first. But maybe to provoke that a little bit, I want to ask a question of my own, which is the one thing that we haven't really talked about yet. Well, there are lots of things we haven't talked about yet, but one of the things that hasn't come up is the curious position taken by the Obama administration in its amicus brief in the court, and in particular the view that the Alien Tort Statute should perhaps allow for liability in some foreign cases, but not where it is a corporation in one country being sued for acts committed in another. It didn't seem like that argument had any fans on the court yesterday, but I'm curious if the panelists have thoughts about whether that's an intermediate position between the two poles here, whether the court might actually see it as a way out of this, and whether John, as the former legal advisor at the State Department, can explain why this brief was not signed by his successor, Harold Koch.
Yeah, thank you. And Paul will have his own view on this because you've all already expressed disappointment in the Obama administration's position. I forgot to mention this. This is one of the most interesting things about the case, and it proves the point, and I want you to sort of take this home, is why it's frankly so difficult to be a government official. You know, you have to represent all of these competing interests. While on the one hand, yes, you want to provide lawsuits that can provide accountability for bad human rights abuses around the world, but at the same time you want to uphold international law and prevent abusive reciprocal actions. In the first round of briefing, the Obama administration filed a brief which people in the human rights community applauded, saying, yes, corporations can be held liable for violations of international law. That was maybe not a surprise. In the second brief, and what surprised many people, the Obama administration, in fact, sided with Shell and said, no, this case should be dismissed because it's inappropriate for the Alien Tort Statute to be used to supply jurisdiction for U.S. courts to hear a case brought by aliens against a foreign company in a foreign country for aiding and abetting the acts of a foreign government. So you had the Solicitor General of the United States yesterday arguing that this case ought to be dismissed Now, then they wrote a sort of a waffly brief, which didn't really lay out any principles, and he really got pummeled for this yesterday, because he said, well, this case ought to be dismissed, but I'm really not going to tell you how to address any other cases other than that we think that Florida maybe ought to be preserved. But actually, even the Solicitor General didn't say that. The Solicitor General in the brief, and what has got to be one of the most interesting sentences in the brief, has said, the Department of State has advised this office that in its view, Florida was properly decided. So that's about as far distancing as you can imagine. And I think that reflects this discomfort about reciprocity. And if you look at the very first line in the U.S. government's brief about statement of the amici, the statement of the U.S. government's interest, it expresses concern about reciprocity and the possibility of reciprocal actions against the United States. So Don Verrilli was really pushed on, well, what principles are you trying to tell us? You're the Solicitor General of the United States. Tell us what rules you think we ought to apply. And he basically said, this case ought to be dismissed, but we would like to go incrementally, and I'll let you know in the future about future cases. That really didn't go down very well. As Steve mentioned, in a surprising development, my successor, the current legal advisor of the State Department, did not sign the brief, presumably because he disagreed with some of the points in it. I can't actually think of a case involving international law before the Supreme Court where the legal advisor of the State Department, who is the key advisor on international law inside the United States government, has not signed a brief before the Supreme Court, and that was noted by several of the justices in the argument yesterday.
I don't think anybody on the court's buying the U.S. government's position. I mean, I don't think it has any, it's clearly, there was an internal war within the administration about what to say. They wrote a brief that instead of resolving that war, was at war with itself. And, I don't think anybody on the court was interested in that position. I don't think it's got the kind of credibility that's going to gather a majority or maybe even any justices. And I think that's part of the reason that the Solicitor General had so much trouble with the argument yesterday. I just don't think he could defend the position.
And he did say, when pressed on this point several times over, I am here to reflect the views broadly of the U.S. government and to balance competing interests of commitment to human rights, protection, or commitment to international law, and concern about the reciprocal treatment. So these are all of the things that have got to go into the mix if you're either the Solicitor General or the legal advisor.
So I have one more question, and while I ask it, let me just say, folks in the audience who have questions, there's a microphone over there, which we'd like everyone to use for their questions. So if you want to start a line back there, we'll call it in when we get to you. So my only other question, which may also give you guys a chance to respond to each other, is about SOSA. Right? I mean, Andrew had, I think, some fairly critical remarks about the view that SOSA might, settle things that some of the litigants think are settled. I'm curious. I mean, are we fighting about what was true in 1789 anymore, or are we fighting about just how far the court was willing to go in 2004? And aren't those two very different questions?
Right. Well, I mean, there's obviously a fight about the history. I mean, I couldn't have more different views from Andrew about the history. And I think the legal historians that filed briefs couldn't have more different views about history than Andrew presented. I mean, I think his history is just completely wrong, and that it can be disproved pretty easily. But the issue about SOSA, it seems to me that part of the discussion there was, and John said this too, would we have been concerned about human rights in France in 1789 as a legal matter? No. I mean, the law of nations didn't have a modern law of international human rights in 1789. What SOSA did was say that when the first Congress decided that tort actions should be recognized for violations of the law of nations and treaties, that in 2004, the law of nations and treaties deals with human rights. That there is a modern law of nations, a modern law of human rights, and that Congress' intent intent was not to implement the Blackstone norms or just the norms of 1789. They said explicitly that this statute applies to comparable norms in our times. And the whole point of Filartiga was that the pirate of 1789 had become the torturer at that point of 1975. And so that the Allen Tort Statute in Sosa was accepted as applying to at least some category of very serious human rights violations. I think that is, I know Andrew made fun of my word essence, and maybe that's the wrong word to use, but when the court, as Justice Kagan reminded the litigants yesterday, said, we endorse the reasoning in Filartiga and the Marcos case and these other cases, that probably meant something. That it meant that they were intent on enforcing those kinds of norms. And they created a test that said that modern norms had to meet the comparable specificity and support and universality as norms like piracy. It didn't say only pirates could be gotten, It said, there were other norms that could be enforced. Now, I agree that there were other issues that were left open in Sosa, but it seems to me at that point, there's no question that Sosa accepted that the modern law of international human rights could be enforced or recognized in this kind of way to some degree, at least.
I think if you look at the transcript from yesterday, Justice Kagan actually read from the Sosa transcript, and she quoted from it, quoting from Filartiga, for purposes of civil liability, the torturer has become like the pirate and slave trader before him, an enemy of all mankind. And then she went on to say, so we gave a stamp of approval to Filartiga and Filartiga's understanding that there were certain categories of offenders who were today's pirates. That's Justice Kagan.
John, anything you want to chip in?
I'll just say one thing, and then we've got a line of people here. I just want to put another point on this. Is I think Paul. I think you see it in front of you. Paul's conceded. Maybe you won't say it's conceded. That they are. These cases could not have been brought in 1789. This is not what the framers thought in 1789. The question is that what the law ought to be today? And there are very good arguments that is what the law ought to be today. Because human rights law, I've spent more time in discussions with international human rights lawyers in Europe and around the world than you can possibly imagine. And so I know where human rights lawyers around the world would like to move the law. And there are good arguments that's where the law ought to move for more sort of international. We have currently right now international criminal jurisdiction in international criminal tribunals and in the International Criminal Court. But international civil jurisdiction, the idea that somebody can be sued in another country for acts that have no a nexus to that country, is not yet a principle of international law. Should we move it in that direction? Maybe. Are there reasons not to do it with respect to the protection of U.S. government officials and so forth? Yes, there are also. But at the end of the day, as far as does the United States do that, who should make that decision? Should Congress make the decision, as they did in the Torture Victims Protection Act, and say, we think this is a good thing, but we want to allow these types of cases to be brought with this statute of limitations after this certain exhaustion? That's what they did in the TVPA. They had hearings. They then crafted a law that fit particular categories, and then the elected representatives, the American people, decided these are the kinds of cases that we want our courts to hear around the world. Or do we want judges on their own to decide what they think the law ought to be, because those 25 words or so in the Alien Tort Statute of 1789 aren't clear. So,
but John, when you say judges on their own, I guess this begs the question, right? In the context of military commissions from 1916 to 2006, right? Federal law authorized military commissions for offenses against the laws of war, right? Congress didn't define the laws of war. So, are we to understand the laws of war only by reference to what was a violation of the laws of war in 1916, or does the statute empower courts in interpreting the phrase laws of war to actually look at what has evolved in the international laws of war? I'm
just saying Congress has done this once before with respect to the Torture Victims Protection Act and defined the parameters where they wanted federal court staff jurisdiction. In this case, which is the more appropriate way to do it? I mean, there are arguments on both sides.
But you're telling part of a story there, because first of all, Congress did pass a law that said that the courts could recognize torts in violation of the law of nations. They didn't say law of nations in 1789. They didn't say piracy. They said the law of nations, understood as customary international law. And customary international law now includes human rights. Congress, when it passed the Torture Victim Protection Act, said explicitly, the Allen Tort Statute, we want that, we like that. They read Florida on the floor of the Senate, and they said, we want the ATS to stay. And in Sosa, the Supreme Court recognized that Congress, when they passed the Torture Victim Protection Act, were passing it explicitly to reject the arguments that you and Andrew have been making about the fact that it was limited to 1789. And in terms of our allies, the European Union, which includes most of the countries that you mentioned, filed a brief in this case that said there was absolutely no problem under international law with the application of the Alien Tort Statute, including in this case, and that the principles of universal jurisdiction were accepted, that they included civil liability, and that the only other thing that should be added is an exhaustion of local remedies required.
That's not the way Justice Sotomayor read that brief, who basically said, why shouldn't I follow the European Commission's brief
and I said, fine.
Toss this case out of court? But,
if we try to reach consensus between the two,
we can work it out together.
My Mets are going to win a playoff title before that. So why don't we turn to questions?
Probably right.
Yeah. Please identify yourself before you ask your question.
My name is Michael Castle-Miller with Public International Law and Policy Group. My question is kind of about how they're going to end up defining the boundaries of the ATS with this case. And it seemed to me from the hearings that, one of the ways they might try to kind of limit this is by, the nexus to the United States. So my question is, in this case, the connections seem to be Shell does business here. The plaintiffs are now living here, found asylum here. Do you feel like that is more of a nexus to the U.S. than Sosa or Filartiga, or less of one? Is this kind of stretching it, or is it well kind of within the boundaries that have already gone before it?
Well, I mean, in Filartiga, I think the connection to the United States was less than it is in this case. And I don't know if that's the way they're going to go. One of the issues that we haven't really even touched on yet is the Alien Tort Statute as an alternative to litigation in state courts. And everybody agrees that our plaintiffs can sue the Shell defendants in state court. There's no question about that. And all the same issues would come up in terms of the active state doctrine or other kinds of problems. And in fact, there are loads of jurisdictions around the world that exercise extraterritorial tort jurisdiction, including the United Kingdom and the Dutch. So one of the questions is it better to have these cases litigated in federal courts under uniform international standards where the federal courts, including the Supreme Court, can supervise that process? Or is it better to just direct us, those of us who litigate these cases, to 50 states where the state courts handle all these questions and the Supreme Court has even less of a possibility of supervising issues that are of importance to the United States and require uniform federal treatment? So that's not exactly responsive to your nexus question, but I think that's relevant to it.
Thanks. My name is Michael Stone. I'm a student at Washington College of Law. I'd like to follow up on the hypothetical that Mr. Bellinger had in his remarks about advising the Secretary of State to an assertion of jurisdiction against her because of drone strikes in Yemen. It seems to me that those circumstances are different in that you have an act of a senior government official in that capacity, and also the strikes have apparently been authorized by the government of Yemen, and thus couldn't you frame that as one sovereign coming to the assistance of another sovereign, which is perfectly legitimate within international law? And it seems that those circumstances are defensible, and the State
I mean, the problem is that's a different doctrine. I mean, you're right. If the Secretary of State were actually sued outside the United States, we would argue that she had immunity under the head of state immunity doctrine. But that if you're the legal advisor to the Secretary of State, I would like to see you argue to Hillary Clinton, don't worry, Madam Secretary, we're going to encourage these cases against you around the world, but at the end of the day, after several years of litigation, you'll be fine. And I mean, honestly, this is right now, international law does not recognize international civil jurisdiction. So the question is, does the United States want to encourage that, recognizing that it's probably more likely to be used against the United States and its officials than perhaps anyone else in the world? And so if you are, again, back to your point, this is an important point for you all as students. At this point, you need to stop being political scientists, and you are now a lawyer for a client. So you are the lawyer. Say you're the lawyer then for the Secretary of Defense, for Leon Panetta. Do you tell him, it is so important for these cases to be heard in the United States so that we can right these wrongs around the world, that you, the Secretary of Defense, should support these around the world. And don't worry if you get sued, because at the end of the day, the United States will support you. I mean, you can make that argument. I think your principal is probably not going to agree with you as his or her lawyer. And so the question is, do we want to encourage these things around the world?
I would broaden the hypothetical perhaps a little bit, I think, to get around that particular sort of defense. I mean, what if we're talking about the companies that manufacture the drones or that service them? I'm assuming, of course, for purposes of argument, that those sorts of lawsuits haven't been brought yet. But it wouldn't surprise me if they had, or if they will soon be.
And actually, let me add one last point, and we'll go to this. I mean, many people, I get asked all around the United States, why didn't the United States become party to the Rome Statute? Which, for all these same reasons, one can understand, the United States has historically always stood up for accountability. Congress actually passed a resolution saying there ought to be an international criminal tribunal. But at the end of the day, it was the Defense Department in the Clinton administration that was concerned that an international criminal court would ultimately be used against the United States. So, yes, there's real value for an international criminal court. I just wrote an op-ed a few weeks ago in the Washington Post on the 10th anniversary of the Rome Statute saying, while it's unlikely that we're going to become party anytime soon because the Senate's not going to approve the Rome Statute, that we ought to cooperate with it more and more. But the inside the U.S. government, there are real concerns about having law being used against the United States.
Can I say something? Especially, again, because we do have a lot of law students here, and I agree that it's important to always be thinking about your client. And so I'd like to put a little bit of a different spin on something that was said earlier, which is it's difficult to be a government official, and that's what these cases bring up. Well, I'd like to say on behalf of my clients, it's difficult to be a torture survivor. It is difficult to be a survivor of rape and slave labor. And it is the wrong, in my opinion, the wrong outcome to take away the only access that they have to justice, to slam the doors and say, you, torture survivor, can't even try. You can't even come to court and tell your story and try to seek justice and try to then overcome foreign nonconvenience and political question and exhaustion of remedies and all of these things that are available to defendants to kick their case out of court. So for my clients, it's hard to be a U.S. government official. I'm not that sympathetic to that. They have a lot of opportunities to have these conversations and resolve these issues.
Let me just say that we will go. These are the emotional arguments that we have inside the government. Professor Ehrlicher's been inside these meetings when you try to balance all of these different concerns. The United States, in any administration, Republican or Democratic, does more to promote human rights than any country in the world in terms of the things that we do, the money that we provide. The question, and so I agree with there needs to be accountability to these things. The United States provides many avenues for accountability. The question is should the United States government be urging this statute, which was not passed this way by Congress, to provide jurisdiction in these cases? Is that something that the U.S. government should support or not?
Look, in this particular case, let's just think about this case. The idea that if we get to sue these two corporations, that Hillary Clinton is at risk of anything happening to her is nonsensical. I mean, it's just nonsensical. The Netherlands and the United Kingdom are not, I mean, our relations with them are not going to be hurt if there is litigation of this sort. There's litigation involving corporations on a range of issues around the world, on antitrust, on securities law, on all these things. Why should we disadvantage human rights victims when it comes to these principles when corporations are involved in litigation on a whole range of subjects? Your firm makes its living on that.
Obviously, the Obama administration, which has a lot of people committed to human rights, had a different view on that, and that's why they...
Well, the Justice Department anyway.
The Justice Department. In fact, the United States has not said that this particular case raised any foreign policy issues, and Nigeria took no position in the case, and the United Kingdom and Netherlands, to my knowledge, have never protested the case. They have just filed a brief talking about how the Allen Tort Statute might be interpreted, and the European Union, of which they're a part, says there's not a problem. So, it's just that, I mean, there may be cases where governments have filed more vociferous protests. I mean, the apartheid case was one of those cases where the South African government was opposed to the apartheid cases that were originally brought. But one of the lessons of that was that when the cases came back down from appeal and were modified to change the claims for relief, to take out some of the defendants, the South African government filed a document with the court saying, we don't have any problem with this anymore. This is fine from our perspective. You have alleviated our concerns. In the Doe versus Exxon case, the same thing happened. Indonesia protested initially. The district court judge modified discovery and limited it, and there were no further protests. And so these are things that can be handled in litigation, and they come up not only in the human rights field, they come up in a variety of other fields, and they are handled in the same sort of way.
So I hate to say that we're actually out of time, but maybe after the court has out decision, we can bring you guys back and continue this conversation. That is not going to end anytime soon. Those of you who still have questions for our speakers, please feel free to come up afterwards and ask them. I'm sure they'd be happy to chat with you. And otherwise, I hope you'll just join me in thanking our speakers today for a lively discussion.